Hey, this is Warren Redlick. I'm going to do a longer video about what happened with the Delaware judge rejecting again Elon's pay package from Tesla. This is the story. The judge rejected it again. There was a shareholder vote. The judge rejected it once. There was a second shareholder vote after the trial decision. The judge rejected that as well. And I have a bunch of notes for you that this is the stuff I'm going to talk about, my analysis of what everybody's seeing. And I'm going to dive into all of that. This is a summary right here. This is a summary of the judge's decision. Now, the judge's decision addressed both whether they should overturn the earlier decision, whether she should overturn the earlier decision and reinstate the pay package. That was a small part of the decision. A larger part of the decision was awarding $345 million. I think that was the number to the plaintiff's law firm. And that was, I think, more than 2/3 of the pages in the decision, maybe even 3/4. And I'm not really going to talk about that much because actually I think the award was like much lower than what I expected and far, far lower than what they were asking for. Some key details here. The judge's philosophy, I want to stress this. The judge's philosophy is in this part. Basically what she's saying is she identifies with the law firm that is suing Tesla more than she identifies with the shareholders of Tesla. Imagine if after a stockholder, as if there's a stockholder who actually cares about this. This is a plaintiff's law firm that found somebody who owned 9 shares, but she's treating it as if there's this minority shareholder who, because that's the fiction that is behind shareholder class action lawsuits, these class action lawsuits, is it's not really that there's some shareholder who's upset. It's there's some law firm that thinks that they see a pot of gold at the end of the rainbow and they go find a shareholder they can use. There's a bunch of procedural hurdles to be able to do this lawsuit. And the law firm that sued did a lot of work, jumped through a lot of hoops in order to be able to get to where they got. She says, imagine if after a stockholder successfully clears these hurdles and achieves total victory, a perpetrator of fiduciary misconduct, I don't agree with her characterization, but that's what she found in the original decision, could then hit reset through stockholder vote as the defendant seeks to do here. Such a practice would eviscerate the deterrent effect of derivative suits. Her view is the point is not to protect shareholders' interests. It's to deter boards of directors from doing things she doesn't like. As a shareholder, well, it's supposed to be in the interest of the shareholders. The whole idea of the lawsuit is it's supposed to be in the interest of the shareholders. And I want to be clear about this also. It's not just her. What she's saying is basically Delaware law, that once you have a class action lawsuit, it's not about the shareholders anymore. It's all about procedure. It's all about playing games. And then when you have the decision that she rendered, which she says law of the case doctrine finality, she didn't issue a final decision. So she did leave the door open for saying there's no finality here. In the face of policy basis of all relevant rules of procedure and law of the case doctrine. See, this isn't about the shareholders. This is about rules of procedure and doctrine, legal doctrine, finality, efficiency, consistency, and the integrity of the judicial process. See, we wouldn't want shareholders to interfere with the integrity of the judicial process. We wouldn't want the interests of shareholders to interfere when the plaintiff's law firm pretends to be representing the interests of shareholders. We're not interested in the interests of shareholders. The plaintiff's law firm's not interested in the interests of shareholders, and the judge is not interested in the interests of shareholders. She's concerned it would eliminate the deterrent effect of derivative litigation. And really what we want is we want an end to derivative litigation. This is what's wrong with derivative litigation. Derivative litigation is not about protecting shareholder interests. It's about rewarding plaintiffs' lawyers. It's about procedure. The procedure swallowed the point. The point should be to protect shareholder interests. And that's clearly not what she's interested in. Just getting into details here, there's another point here where she doesn't respect shareholders. The central thesis of the ratification argument is one of agency law that stockholders are principals of the corporation, directors are their agents, and as principals, stockholders can do what they want in all contexts. Right? And Elon says this in one of his posts. Shareholders should control company votes, not judges. Right? And she rejects this is the critical distinction. In defendants wherein stockholders hold the power to adopt any corporate acts they deem in their own best interest. The flaw with this thesis is that directors and officers are not agents of the stockholders, nor are the stockholders their principals. I don't think she makes sense here. It's not about agency. The shareholders voted. clearly, resoundingly, and she's rejecting the shareholder vote. So that's a short description of what the court did. I've got more. And I just want to stress, when I do the full video, which I haven't done yet, I have a whole bunch of quotes and posts primarily from people who are critical of the decision. So here's Chamath saying this is damaging to the U.S. economy. There's a lot of people saying this is going to be difficult. This is going to be a problem for Delaware. Investors will lose faith in Delaware and the judicial system here. I'm going to discuss that. And another one is, this is Michael Levin. He is on the other side of us. He is a guy who's rooting for Tesla to lose. And there's some stuff that he says in this article. This article is after the first decision, after the proxy statement was released for the second shareholder vote. And he says some very interesting things in here. But this is a guy who's rooting against Tesla, and he says some things that I take as positive for Tesla and contrary to what the judge ruled in this case. So I'm going to dive into all that in the longer video. The longer video will be available to subscribers of me on X, to YouTube channel members, to supporters on the Daily Lie, and supporters on Patreon. And I will post clips from those videos for everyone else. But following Elon suggested doing this intro video to let people know what's coming. And if you really want to get a deep dive in this, and for those who don't know, I am a mostly retired New York and Florida lawyer. I understand how to read judges' decisions. This is not my area of law. I did handle one case like this when I worked for a judge. There's no case like this, but I did handle this kind of general litigation once when I worked for a judge. It's not my area of law, but I can definitely read a judge's decision. I definitely understand the case. And I think I'm laying out here what's going on. So if you want to have a more complete understanding and get a response to this, it's there. I'm doing a space, New York, 9 a.m. Eastern, December 3rd. There'll be a space on the X platform that's open to everybody. Verified users can come up and ask questions. That's late for me here in Thailand, so it won't last that long, and I'm going to go to bed. And then the full video will be published the next day, or maybe later the same day, but probably the next morning. So thanks everybody so much for watching. Please support me on one of the platforms if you'd like to get the full content. Bye-bye.